We wait for complete reports. That is my office's policy.
You can't prove and charge any of these, so you don't want to file anything?
I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. So you are discharged from all bail forthwith. Now, cash will be returned to you, bond, gonzo.
Before we dive into today's dramatic courtroom battle, here's the reason this case has everyone paying attention. A man was taken into custody, required to pay a $1,000 cash bond, and forced to live under strict court-imposed conditions for almost a month. Yet despite all that time, prosecutors still hadn't formally filed a single criminal charge against him. That's the moment this case takes a dramatic turn. What begins as an ordinary court hearing quickly transforms into a high-stakes clash over constitutional protections, due process, and one critical question. Can the government continue restricting someone's freedom without officially moving the case forward? Stay with us, because the judge isn't simply ruling on one defendant's future. He's putting the county's entire approach to arrests, charging decisions, and legal accountability under the spotlight. By the time this hearing comes to an end, you'll likely be left wondering whether this was a landmark stand for individual rights or a long overdue warning that the justice system itself needed to be held accountable.
1 o'clock, but it is a GF, and this man and his wife just walked 2 hours to be here this morning, and I don't believe that we have anything filed, do we?
No.
You can have a seat, sir. It will go on the record in the matter 26 GF 133, group file of Brandon Campo. Appearances are we do have appearing in person the district attorney Kevin Schmidt. Mr. Campo appears in person without counsel. We are in victims' rights compliance because the victim is sitting right back there, Ms. Bauer. That is the victim. Look at her face. That is who she is. And so we have Mr. Campo here. This matter, he was brought before the court for the court to put him on a cash bond, a significant cash bond on May 26, 2026. There was enough there for the court to make a probable cause finding because the court does have at least a small police report in this matter. And so he's here. It was scheduled at 1 o'clock, but the man and his wife have walked 2 hours to get here. Correct, Mr. Campo?
That's correct.
You don't have a means of transportation?
No.
And so why are you here at 1 o'clock? Or why are you here now instead of 1 o'clock?
I was trying to get the court date changed because I don't have an attorney.
Because you don't have an attorney, but I understand that, but you don't even have charges filed against you. You understand that part?
So I didn't have to appear?
I would say probably no, because there's nothing filed, but you do have cash, $1,000 cash that was posted based upon a very lengthy probable cause statement with facts enough that you could have been charged or probably should have been charged by now, since it is June 24th. Almost a month past the date. You are dressed very nice for court. Thank you for wearing a shirt and a tie. You look fantastic.
Thank you.
Why don't we have anything charged? Almost 1 month. Almost 1 month to the day or two later.
Because one of the charges lacks probable cause in the police reports.
Then don't charge that charge, but he should be charged by now.
No, because I've asked for police follow-up to find the probable cause for that count.
I thought you started something in Polk County where the day that they're arrested, they get probable cause, they get their initial appearance, they have a complaint filed. This should happen here too, because it's almost 1 month since this man was arrested, put on bail with significant cash of $1,000 with bail condition. If there's one count that is not yet enough for probable cause, then you can ask to amend the court. You know the statute, you know the rules. But now we have a man here he's been under a bail bond condition for almost 1 month with $1,000 cash, and we don't know if there's enough to charge. There's enough at least for probable cause for some of these. You can amend later. You can even amend an information upon preliminary hearing. Right now, this is ridiculous that it's almost 1 month since his arrest, since he was put on cash bail, that he has not been charged.
Judge, we wait for complete reports before filing complaints because our policy is that cases are provable and triable the day we charge them. It's not right now. That is my office's policy.
You can't though?
If
You
the
can't
court-
prove and charge any of these, so you don't want to file anything? Because again, discussions of the fact that when you worked at Polk, you developed this system and it's to have all of these things. I don't know if you did that or who did this, but when a man's arrested or a woman's arrested in a lot of counties in the state and per the statute, they are to be immediately provided their criminal complaint. Is it directory? Is it mandatory? Who knows? But in a lot of counties, it happens the day of arrest. And there are amendments to the criminal complaint or amendments to the information. But now it is June 24th. And again, this man was arrested on May 22nd, he was arrested. May 22nd, he was arrested. But the court did place bond and cash on him on May 26th.
Correct. If the court conducted a bond hearing within 72 hours of arrest, I could have told the court this, but our county doesn't do that.
Our county should do that. Our county should do that because I guess I'll pull up the statute right now. Because people's rights are restricted. That's why most, or a lot of counties, I can't say most, because we're one of the little counties that apparently don't want to do that. I'm sure you know the statute and you can probably pull it up a lot faster than I can since that is your job every day. The state must file a complaint without unnecessary delay following arrest, which generally can be interpreted as 48 hours. 48 hours. And that's not just for the court to determine bail, but it should be filed. It should be filed with unnecessary delay.
This is the point where the hearing stops focusing on a single defendant and starts putting the entire legal process under the microscope. The judge zeroes in on a key legal principle. Once someone has been arrested, criminal charges are expected to be filed without unnecessary delays. The prosecutor, however, presents a different approach. He argues that his office prefers to wait until it believes the evidence is strong enough to prove the case beyond a reasonable doubt before officially filing charges. Those two viewpoints couldn't be more different. One side believes protecting constitutional rights means acting quickly and avoiding unnecessary delays. The other believes it's better to build the strongest possible case before taking the next legal step. That's exactly why this courtroom exchange becomes so compelling. It's no longer just about filing documents. It's a debate over how the justice system should balance public safety, fairness, and the constitutional rights of every person involved. Now, we want to hear your opinion. If someone has already been arrested and placed under bail conditions, should prosecutors file charges right away and update them later if needed? Or should they wait until investigators are confident every important detail has been fully established before moving forward? Share your thoughts in the comments and let us know which approach you believe is the right one.
And to this court, this has been beyond an unnecessary delay. When a person is arrested without a warrant and brought before a court, before a judge, a complaint shall be filed forthwith. Forthwith.
This person was never brought before a judge. bond was set in his absence.
The probable cause was brought before the court with enough information for the court to determine probable cause. So if we're going to start having people arrested and they're going to be brought before the court, then forthwith a complaint will be filed and we will start having bond hearings every single time a person is arrested. This is outrageous. It is completely outrageous.
I would approve of that process. That's why Captain Taggart asked the court to.
Oh, good. Then we're going to start doing that now. And so we will have a complaint filed forthwith at the bail hearing, correct?
We will not.
Then we will not arrest people. Then they will be not arrested and we will not see them because bail should not be placed on a person unless a person is arrested without a warrant and brought before a judge, which they will be. A complaint shall be filed forthwith. And if other counties, including Polk County, can file it and get it done the day of the arrest, within hours of an arrest, I think Burnett County can do that too.
We will file it forthwith after those bond hearings if the court starts bond hearings.
All right, then I'll do that and we'll have the bond hearing and then the very next day we'll have the initial appearance. That was forthwith for the court. So is that what we're going to do, Mr. Schmidt?
I'd have to confer with law enforcement because they have not been consulted with this yet and not been given an opportunity to prepare.
There's enough. Do you understand what the PC comments or complaints that are filed, the probable cause complaints? They have a lot of information. They are puked with a whole lot of information. The officers do such a fantastic job for the most part in those probable cause statements. Enough where a complaint can be filed. Enough. I can even read this complaint that was filed by the Siren Police Department. There is enough there, right there, enough there that a complaint can be filed. That is forthwith. And all you do is cut and paste and put their complaint into the complaint or their police reports into the complaint anyway.
Judge, the probable cause statement, you may have noticed, does not state when the drinking occurred in regards to when the crash happened. It does not state when the moment of driving was. It does not state whether an officer was actually spat on or not. And it does not say whether anyone was injured in the crash.
Well, then that is a Siren Police Department issue that you can talk with Siren Police Department. But I'm going to tell you, our county boys and girls and women and everybody, all of our county people, our county officers and deputies, they put a lot into their probable cause, a lot.
They do.
And so then I guess with Siren Police Department people, if that's what you're saying is the issue here, then perhaps they need to be trained on how to put in all of the information in a probable cause so we can forthwith have charges.
And again, I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. Then we cannot have bail or bond conditions. So people need to be let out immediately, forthwith.
We can have bail conditions set based upon probable cause statements and the complaints can be filed forthwith. We have the capacity to do that so long as law enforcement knows and they can prepare for it.
All right, forthwith, within 48 hours, I will do bail. Within 48 hours, we will have the initial appearances in every single arrest, every single that comes in front of this court for bail and bond.
Okay. I will speak with law enforcement of what the court's command is. I am going to be gone for the next 2 weeks, so there will be that problem.
Because to me, forthwith does not mean 1 month and 2 days after an arrest. That is not forthwith.
It does not. If there was a bond hearing, I would have told the court to do a signature bond for these reasons.
I would not do any bond, zero bond, none bond, because unless it's forthwith within 48 hours, nobody should have their due process rights taken away because we can't get a criminal complaint filed forthwith.
I agree. It is unreasonable for people to be on a cash bond without seeing a court and no.
Any bail bond conditions, any, because right now, this individual, if I have him on bail bond conditions, this individual, and he's not getting a complaint filed a month and 2 days after, why should he risk to have bail bond jump violations when he hasn't even been charged? He doesn't even know if he is going to be charged.
I agree.
So zero bail, zero bond, unless we have a criminal complaint filed forthwith within 48 hours.
I agree.
Done. And that's what we're going to do. So, Mr. Campo, I'm not sure if you are supposed to have a complaint filed today. I'm hearing no.
Okay.
So you are forthwith discharged from all bail bond conditions. Forthwith, now,
Really?
immediately. Cash will be returned to you, and bond gonzo.
Amazing.
Okay? Thank you.
Thank you.
What an incredible way for this courtroom hearing to come to an end. After reviewing the circumstances, the judge ruled that because no formal criminal complaint had been filed, despite the extended delay, Mr. Campo would be released from every bail restriction immediately, and his $1,000 cash bond would be refunded. But the ruling reached far beyond one individual case. The hearing evolved into a much larger conversation about how the county should handle future arrests and bail proceedings, with the goal of better protecting defendants' constitutional rights while still giving prosecutors the opportunity to build solid cases. Whether you agree with every argument made in the courtroom or not, this case is a powerful reminder that procedural decisions can dramatically affect someone's life long before a jury ever hears the evidence. If you enjoyed this courtroom analysis, be sure to leave a like, tell us your thoughts in the comments, and subscribe for more detailed legal breakdowns, courtroom highlights, and the biggest judicial moments as they unfold.